Good morning, everyone, and welcome to Panel 13, Sustainable Fuel Technologies for the Green Transition in Light of Trade Law, Time to Reshape the Trade and Conflict Nexus. We are honored to have with us a distinguished group of speakers who will explore this important topic over the next hour and a half. It is my pleasure to first introduce our moderator, Dr. Ilaria Espa, Associate Professor of International Economic Law at USI and Senior Research Fellow at the World Trade Institute. She is joined today by three excellent panelists, whom she'll introduce individually in a moment. Now, without further ado, I'll turn the floor over to Dr. Espa.
So much for this kind introduction, and good morning to everyone. Thanks so much for joining us for this panel of Sustainable Fuel Technologies for the Green Transition in Light of Trade Law. As mentioned, I am Ilaria Espa, who will be moderating this session, and I'm delighted to have a wonderful set of panelists who are going to delve into this topic together. I'm just going to give a few words of introduction, and then I'll be introducing each of the contributions. So our panel really means to address two basic fundamental questions. On the one hand, what are the regulatory challenges that are brought by the advent of sustainable fuel technologies, and in particular those of new generation, which require a reconfiguration of cross-border supply chains and imply a major shift in international trade patterns? And then the second question is whether, and if so, to what extent can the trade regime positively contribute to promote scalability of those technologies, which is, of course, going to be critical to meet the net zero targets that an increasingly high number of jurisdictions are assuming in accordance or in the attempt to meet the Paris Agreement's goals. If this is actually not the case, then we will also explore how we could still ensure for technology-informed trade solutions, and to which extent would that require a recalibration of the trade and climate nexus as we know it. Now, through the various presentations, we are going to address a range of sustainable fuels, not the entirety of them, because of course technologies are really very much developing as we speak, but we are going to have a quite representative sample of fuel technologies as a focus, going from more classical biofuels through renewable fuels of non-biological origin, including hydrogen, and then we are going to switch also to having a focus on synthetic aviation fuels, or so-called e-fuels. The fil rouge is that, of course, all of these fuels are needed to ensure the decarbonization of so-called hard-to-abate sectors. So, for instance, eSAFs, or synthetic aviation fuels in the aviation sector, or are also going to be critical for addressing some of the fundamental challenges, including infrastructural challenges for those sectors where electrification is available, but not at the pace and scale that is actually needed. So, for instance, green methanol that could be used in existing engine in the road transport sector, just to name one. Of course, these fuels, however, entail different value chains. They have different levels of so-called technological readiness. They have different levels of market readiness, and of course also different levels of policy readiness, which affects the type of approaches from regulatory side of things, and therefore also the potential use of trade instruments to address scalability issues. Now, we'll start with classical biofuels with the first presentation, who's going to be delivered by Dr. Kateryna Holzer. Kateryna is a senior researcher at the Center for Climate, Energy and Environment Law at the University of Eastern Finland, and she will give a presentation on balancing economic and environmental objectives, lessons from the WTO disputes over biofuel sustainability standards. Kateryna, you have the floor.
Thank you, Ilaria. Thank you very much also for coming to our panel. Let me start my intervention with the issue of or the problem of the diversity of sustainability standards. You know that different carbon footprints can be generated for the same product from the same country if the different methods of emissions accounting are used. And this is bad. This is bad first for the consumption for consumers, because it confuses consumers and undermines their trust in the integrity of sustainability standards. It is bad for climate policy and for the achievement of climate policy objectives, because standards which are inconsistent and which are not interoperable, they cannot be effectively used to achieve climate policy objectives. And it's also bad for trade, because it raises costs of compliance, because producers have to adjust their products to different standards in different markets. And then it, of course, raises costs, and it leads to trade tensions, which eventually also result in trade disputes. And this is how these two disputes were brought to the WTO on the EU requirements for biofuels that are used to comply with renewable energy objectives of the EU. And I'm going just to speak about these disputes, because palm oil disputes, because they are important, and they have the findings of the panel have important implications for the future, disputes on environmental matters that can be brought to the WTO. So the measure which was challenged by Indonesia and Malaysia, it was the Renewable Energy Directive of the EU, and particularly the second version of that directive, recast of 2018, RED II. And that directive prescribed 14% of obligations of the share of transport fuels that will need to be achieved through renewable energy, through fuels produced from renewable energy. And of that 14% of renewable energy fuels, only 7% could be, 7% of all fuels used in transportation, half of that 14% quota, could be achieved through biofuels produced from crop-based biofuels. But the problem was that the EU actually excluded palm oil-based biofuels from that share of crop-based biofuels. More precisely, it didn't exclude them, but it used the methodology that was based on the presumption of indirect land use change, ILUC, to protect against the risk of indirect land use change, and the criteria that were applied under that methodology excluded palm oil-based biofuels, not other crop-based biofuels like products, for instance, based on soya or imported from abroad, or rapeseed, which were produced also in the EU and are still produced in the EU. But particularly palm oil biofuels, we are subjected to that prohibition from using towards compliance with renewable energy targets. And that methodology based on indirect land use change, which actually means that it is a presumption that if land is used for the production of for growing of crops, for instance, palm trees to be then used to produce biofuels, then there is a presumption that that land is occupied, and so there might be extra land needed somewhere else to just compensate for the occupation of that land for the production of biofuels and for agricultural, for instance, production. And then other land which will be used for agriculture, it's an additional land, and it may the cleaning of that land for agricultural purposes could then result in extra emissions. And so this is called indirect land use change. And so this is methodology that was used by the EU to differentiate between high ILUC risk biofuels, crop-based biofuels, and low ILUC risk biofuels. And the criteria were designed so that only palm oil-based biofuels were subject to gradual phase out from this compliance towards renewable energy targets. And so Indonesia and Malaysia didn't like that approach, and because, well, they had high stakes in that matter, because in both Indonesia and Malaysia are the world's largest producers of palm oil in general, and also palm oil-based biofuels. They argued that this methodology, which encompasses the ILUC, indirect land use change risk, it is subjective, because land change can happen or it cannot happen. It depends, and you, in any case, you cannot count with precision the amount of emissions that could be resulted from this ILUC. So they brought a complaint to the WTO, Malaysia, Indonesia, against the EU, and they invoked several provisions under several WTO agreements, including the TBT agreement, but also the GATT and the subsidy agreement. But for the rest, for the remaining of my time, I would like to concentrate on the TBT claims, violation claims, because these are this central set of rules that apply to sustainability standards. And the panel findings, as I already mentioned, they were quite prominent and quite remarkable for the climate change measures, trade-related measures. Like, for instance, the first finding that I would like to mention was the characterization of the measures. There were two measures identified as measures at issue. It's a 7% of share for crop-based biofuels, and second measure is the phase out, cap and phase out of high ILUC risk fuels. And so this characterization, which I'm talking about, concerned the characterization of these measures either as measures falling under the TBT agreement, technical regulations, or measures falling only under the GATT as internal regulations. And that was important because if they were measures falling only the GATT, then well, arguably, I would say it would be easier probably to pass some tests on compliance because the TBT agreement rules are more specific and more detailed when it concerns the use of standards, especially this additional requirement of not to create unnecessary barriers for trade, not to be more restrictive than necessary. And the panel found that these measures were technical regulations. So there were measures that should be scrutinized under the TBT agreement. And why is that so? Mainly because they found that the quality of products being produced using some particular inputs or some particular raw materials, these can be considered to be product specifications. So that and according to the definition of technical regulation under TBT, that means that these are measures, TBT measures, technical regulation. They were found also to be mandatory, so technical regulations. Then second finding, which was very also interesting, remarkable, it was the finding about the legitimacy of the objective of the EU in promoting only biofuels with low risk of ILUC. And the panel found that this objective related to climate policy, which is also very important. It was for the first time that the objective was specifically related to climate policy. The panel found that that objective was legitimate because it fell in the scope of policies for the protection of health and then also public health and conservation of natural resources, so the environment. And also because there was the nexus between the regulating member and the regulating matter, which is this nexus related to extraterritoriality. But probably we can get back to that issue later. Then the third interesting finding was the finding about the use of international standards. Both Malaysia and Indonesia claimed that the EU failed to use existing international standards, and they pointed to the existence of such standards within the ISO standards, 4 ISO standards. And the panel, although agreed with Malaysia and Indonesia that those ISO standards could be considered to be international standards, nevertheless, the panel found that those standards were not relevant standards. And the EU could actually use, that's why, its own methodology, not necessarily based on ISO standards. And why not relevant? Because those ISO standards, although some of them were talking about ILUC, they didn't really provided methods for calculation of emissions resulting from ILUC, which the EU as a WTO member had the right, which is also stated in the preamble of the TBT agreement, to set its own level of protection for the environment. So, and my last point, concerning the findings, the main findings that the panel reached was the finding of discrimination. And this is where these measures failed to comply with WHO law. So the panel found these two, one measure, but the second measure concerning the phase out of higher look risk biofuels to be inconsistent with Article 2.1 of the TBT agreement, which is the article about non-discrimination, both MFN and national treatment. And why did it find to contradict that provision? Because it could not be the differentiation and treatment of like products, which were identified as soya-based biofuels, rapeseed biofuels, and palm oil biofuels. They did not actually this different treatment. The EU was failed to justify through legitimate regulatory distinction. And this is how the violation with national treatment and MFN, and by the extension also in the GATT violation of national treatment and MFN, and then the failure to comply with the requirements of the chapeau of Article 20 also failed. So the verdict of the panel, the final verdict, was to modify, although it found the measures to be legitimate, it recommended to modify the requirements based on ILUC so that it would bring the EU would bring them in consistency with non-discrimination rules. So thank you.
Thank you so much, Kateryna, for this very interesting presentation on the palm oil cases. Perhaps let me just ask one follow-up question right away, because you hinted at that. You didn't say it explicitly, but I think you very clearly pointed out that the panel was confronted with what we would classically call a ppm-based measure. And you did say that this was, of course, a measure having an extraterritorial dimension. And this dispute was interesting because the panel clarified again that there is no inherent jurisdictional limitation to Article 2.2 of the TBT agreement and Article 20 of the GATT. And this means, of course, that a measure that would protect legitimate interests, and in this case, of course, climate change was recognized as a global challenge in nature, even outside of its territory, through this consumption-based approach could still fly. So I was wondering if you could share perhaps your views on what you think could be the implications for future cases targeting climate-related trade measures. I mean, a complaint by Russia against the UCBAM was just filed, and this is just one of a pool of very controversial measures adopted unilaterally by the EU, including the UDR, for instance, deforestation regulations. So perhaps a few reflections on these.
Well, perhaps I cannot talk now about CBAM or something because it will really need more time. But indeed, briefly, I would like to point out to the importance of this finding on extraterritoriality of the panel. And the panel actually put these kind of measures in the category of inward-looking PPMs. What does that mean? In the literature, probably you can find some publications about it and academic studies that inward-looking, it means that they fall perfectly within the territorial jurisdiction of the regulating state, although they have extraterritorial effects. And how did they come to that conclusion? Is through this, this finding that the EU actually didn't regulate emissions abroad on the territory of its trading partners. Instead, it regulated the demand for these bad biofuels. I mean, I look risk biofuels within the EU territory. So in a way, it protected public interests of its own society, so public consumers, the EU consumers. And so by this, through this finding that the EU actually regulated the demand for these bad biofuels, it in this way, it also had an impact on emissions in general, but because emissions is something that do not have any boundaries, yeah. So, and it relates to the global problem of climate change. The EU didn't actually didn't take extraterritorial measures, although, of course, there were extraterritorial effects. And so this is how this extraterritoriality was taken from, you may, this issue of extraterritoriality was taken from the table. And I think this is also important for future cases in the WTO, now also the CBAM case, because these are can be also claimed that they are extraterritorial measures, but nevertheless, the panel found that such extraterritorial measures, inward-looking extraterritorial measures, they are legitimate. They're legitimate, and so they can be justified because there is this nexus, right? Because the regulating member, the regulating state, and the regulating matter.
Thanks a lot, and I think this is also very relevant for the other presentations. So we move now to RFNBOs, so renewable fuels of non-biological origin, with a presentation by Dr. Tetyana Payosova, who is a fellow at the World Trade Institute and an international trade law and policy advisor, and she will deliver a presentation on the EU approach to regulating RFNBOs in the context of green industrial policy and international trade. Tetyana.
Thank you so much, Ilaria. And my presentation is really a continuation of the renewable energy saga in the EU. And as Ilaria mentions, I will focus particularly on one type of fuels or renewable energy fuels in the EU. Just a second while the presentation's been switched on. It's not my presentation. So to briefly setting out the scene, I will focus on the particular or the key elements of the EU approach to the RFNBOs, and then outline the key international trade considerations. Yeah, apologies for some technical difficulties. And so what we see in terms of the evolution of the approach, of the EU approach, is that the earlier iteration of the Renewable Energy Directive that was challenged in the palm oil case essentially set the broader targets for all types of renewable energy sources, in particular in the transport sector, but also of the all energy use. And RFNBOs were not treated separately, they were part of the renewable energy sources for which the targets were set. In the new iteration of the Renewable Energy Directive, the Renewable Energy Directive 3, that was adopted in 2023, the new targets were set specifically for hydrogen, and also the targets were expanded to industry. So the new targets are 42% in industrial processes by 2030 and 60% by 2035, specifically for green hydrogen, as compared to all hydrogen used in the industrial processes. There are also separate targets set for the transport sector. However, these targets are more marginal. I would say the key targets are for the industrial sector. And then there are also specific targets in other acts that are envisaged for the maritime and the aviation sector. Just very briefly to mention that there is a definition of the RFNBOs in the Renewable Energy Directive. And also there is a definition of low carbon hydrogen for aviation. However, there is no definition as such of, for instance, what constitutes green hydrogen. The requirements, specific requirements for RFNBOs for the purpose of meeting the targets that are set out in RED 3 are specified in two delegated regulations. And this is again, very similar approach, policy approach by the EU, because in the case of palm oil, the specific requirements for high ILUC risk biofuels and the low ILUC risk requirements were also set in the delegated regulation. So very technical, also a very different approach in terms of legislative procedure in the EU. And as we see, the requirements are very, very technical, very detailed. So to qualify as RFNBO within the meaning of the Renewable Energy Directive, these fuels have to meet a set of requirements. First of all, there are greenhouse gas emission saving requirements that are quite typical. They also exist for biofuels. Then there is a requirement that renewable energy, renewable electricity specifically, has to be used as an input. And there are two specific conditions that, again, they have to meet with respect to the use of renewable electricity. And there is a requirement of either, this criterion can be met either through direct connection to renewable electricity facility, or when electricity is sourced from the grid, but then there are again a strict set of requirements. And then more importantly, there is additionality requirement and also temporal and geographical correlation requirements. And here we again see very detailed, very specific requirements. Additionality essentially means that RFNBOs, including hydrogen, should be produced from renewable electricity that has been added. So they shouldn't take renewable electricity that is produced otherwise and can be used otherwise, but rather there should be new facilities that are built and renewable electricity from those new facilities is being used for the production of hydrogen. And moreover, that this renewable energy, renewable electricity facilities do not receive any other type of support or subsidies. So very narrow, very stringent. And as regards temporal and geographical correlation, again, here there is a set of very detailed, very stringent requirements. The temporal correlation is initially monthly, so based on the calendar month. And the starting from 2030, it should be the correlation within 1 hour period, which means actually that the electricity system and electricity regulation should be very, very advanced in a particular country, because of course these requirements apply they apply to the RFNBOs that are consumed in the EU, but they apply equally to those RFNBOs that are produced and that are imported. And just very briefly, yes, exactly. And so this is just very briefly, I'm not going to go into detail, the requirements as regards the sourcing of renewable electricity. And essentially, there are several options, as I mentioned, through direct connection or from the grid. But essentially, again, if you look especially at the sourcing from the grid, the requirements, I would say, are very, very EU-centric in the sense that they are really taking into account the current design of the EU electricity markets. And when you talk to colleagues from other countries, they say, well, we actually don't have this type of even terminology that is being used, but also our markets are just designed differently. So now, to briefly move on to some comments and considerations from the international trade law perspective. So I would say that implications for international trade are inevitable because, as I mentioned, it's not only this type of regulation is not only about greenhouse gas emissions and greenhouse gas footprint of the RFNBOs, but it is about the competitiveness and the competitiveness of the hydrogen industry in the EU. While this is not a prerequisite, these conditions are not a prerequisite for imports into the EU, essentially what the EU did through setting the targets, it created a market, because RFNBOs as such are pricey and they are not competitive on the market as compared to fossil fuels. And so if RFNBOs that are produced elsewhere do not comply with the strict requirements that are set out in RED III and delegated regulations, they do not qualify for the targets and thus do not essentially have a place on the EU markets. And finally, as I have mentioned, the RFNBO standards set out by the EU are very EU-centric. And there is a big question that has been raised already, both within the EU, but also by foreign producers and foreign governments, that for foreign producers, it will be very difficult, if not impossible, to meet the requirements that are set out in the EU RED III and the delegated acts. And thus, at least some of the considerations that have been mentioned in the palm oil cases become very, very relevant also for the rules that are set out for RFNBOs. And I'll stop here and we can discuss some other aspects of this very interesting regulation in a moment.
Thank you so much, Tetyana. You did a marvelous job with summarizing very complex network of regulatory instruments. Perhaps let me just ask briefly a short follow-up questions that takes up on your point about how you set the results QEs. And I see so many similarities, of course, to the measures that were brought this in the palm oil case, but also with probably the presentation we're going to hear in just a few moments. But perhaps can I just ask if you could share your reflections on the implications for third countries that happen to be non-producers of biofuels. Please, we heard from earlier presentations the importance of feedstock and the definition of qualifying fuel and biofuels. Large biofuels, for instance, Brazil, as well. Environment Week last week, they just expressed deep concerns about this regulatory approach, especially in the context of the lack of harmonized carbon accounting standards that are source free for some of the
eligibility criteria here versus the GHG emission setting criteria. Perhaps just very quickly your reflections on that, and then I'll go into the Q&A.
Thank you very much, Ilaria, for this question. It is indeed very interesting and very timely that at the Trade Environment Week last week at the WTO, one of the panels and one of the speakers in the panel from Brazil specifically addressed the RFNBO requirements in the EU, and he pointed out to several elements in the RFNBO requirements that would be problematic for Brazil, but even more so, that speaker highlights that the requirements that are set out in the EU are not really linked again to the greenhouse gas emissions as such of the RFNBOs. So it's more about EU taking or looking at the EU markets, at the EU reality, EU circumstances, and regulating those bases. And so as an example, in Brazil, for instance, the average share of renewable energy across country is, I think the latest data in the green electricity, in the electricity sector, is 89%. The EU threshold was 90% when electricity is supplied from the grid. So it's a difference, a tiny difference of 1%, which essentially would exclude just by this margin of 1%, the qualification of hydrogen produced from renewable electricity in Brazil. But this is just one of the examples. Different as compared to biofuel requirements in the sense that this RFNBO requirements resulted in quite a number of concerns, not only by foreign producers, but also from the domestic EU producers that just said that, look, these requirements are not feasible to comply with. They kill the industry without creating it. So, you know, at the root. And so essentially, I think it was last week, 2 weeks ago, the European Parliament published a resolution in which it called for the Commission to review already the requirements that actually have not yet fully been implemented because of this lack of visibility. And I think this is actually a positive development. So these requirements are not set in stone, and hopefully they will be revised, also taking into account the circumstances in other countries like Brazil.
Thank you so much. Indeed, similar problems concern also the further continuation of the saga. So we went from classical biofuels through RFNBOs. Now we switched to synthetic aviation fuels. And I see similar problems there. The chicken and the egg problem of supply and demand, perhaps also owing, at least partially, to a very complex regulatory web. Without further ado, I
that sustainable fuels could play in the context of the Swiss energy transition, and in the group led by Ilaria, we are, of course, dealing with the interplay of international trade in sustainable fuels and the interplay with energy law, of course, and this also occurs in a comparative perspective, and this is why today I am also tackling EU law specifically, and the interplay with, of course, WTO law rules. So I see that it is set up. Perfect. So as I was mentioning, this is a paper is we selected it as an example of a third country compared to EU countries that is adopting similar measures. And so in the perspective of the project, we can also see where this will lead us for considerations for Switzerland, for example. So of course, we are looking at the legal instruments that have already been mentioned in the context of the EU, so the RED directive, but we also focus on more broadly the ETS directive, and also we look, of course, at the EU aviation regulation. So we add a piece to the legal framework that we have been discussing so far. Behind to identify the most critical issues, elements arising from this regulatory framework within the interplay with WTO rules. Okay, so this is great because this I don't need to go that deep into this slide, thanks to Tetyana that already mentioned the differences between the types of SAF. So we might have biofuels, as it was said, and synthetic fuels. So here, what I might add is that in the context of aviation, as aviation itself is a hard-to-abate sector, given the current state of technology, this is effectively the only way to decarbonize the sector because we cannot rely on electrification yet. And so technologically speaking, we only can rely on SAF. And this is why it is so important to exploit this beneficial effect scale. However, of course, to different SAFs correspond different emission potential reductions. We talk about really, we can range from 1% to 100% depending on how they are produced. And of course, as Ilaria hinted, I think the aviation sector is very peculiar because it involves a sort of also an ethical issue when we talk about sustainability. It's not just about energy, but for example, when we talk about biofuels that are based on food, for example, of course, the feedstock that we use there might be diverted, right, from the food sector, of course. So we might have many food security issues raised or even ethical concerns. And the same goes for other types of biofuels, such as those based on animal fats, because there are competing industries relying on those feedstocks right now, such as the cosmetic industry. And this is why the EU, and as we will see in a moment, is trying also to push somehow towards synthetic solutions in this regard. So to avoid this, to truly, let's say, push towards a technology that is really scalable without additional concerns, let's say, from a food perspective or some other perspectives. We can discuss it later if someone has questions about this. Lastly, I maybe can add that in the context of aviation, sustainable aviation fuels can be used in existing engines, provided that they are technically certified. I want to stress the technically certified because I will talk about certification in a moment, but that's a different certification. So before put in the market and before being actually used in an engine, they need to be technically certified as drop-in fuels. And so you can see the advantage here is that we do not need to change the engines of the airplanes, right, to use these fuels. And so we are allowed technically to still rely on existing infrastructure, which is at least here saving costs. Because of course, as it was already mentioned, synthetic fuels can cost 3 to 10 times more than fossil kerosene, right? So this has, of course, a huge impact on the business models of aviation operators. So right into the regulatory frameworks that we have selected. So I will start with the fil rouge, right? The commonalities between these two. So as I was saying, the idea behind these measures is to stabilize the market of synthetic fuels. And how do they do that? With basically introducing mandatory blending targets on supplier of fuels of EU and UK airports. What does it mean? That fuel suppliers, starting this year, are obliged to ensure that in their fuel supply to airports, that supply contains a minimum percentage of sustainable aviation fuel. And starting from 2028 for the UK and 2030 for the EU, there is also a sub-target. So not only we have sustainable aviation fuel in general to be supplied, but within that percentage, a smaller percentage needs to be mandatorily a synthetic aviation fuel. However, this system is then coupled with eligibility criteria requirements. This means that not all synthetic fuel are eligible to be counted in these targets, but only those that comply with certain sustainability-related eligibility criteria. We'll go back to it in a moment. It's just to step in here. And this, on the face, applies to both foreign and domestic fuel suppliers. So it doesn't discriminate between the origin of the products that are being supplied. Okay, now comes the... Oh, sorry. Right. So now about the discrepancies between these two selected systems. We start with the definition of synthetic fuels, of ethanol. As you will see, this has a number of cascading effects that directly relate to the ability of the EU and the UK itself to actually be able to comply with the targets that they have set themselves. So, under both systems, synthetic aviation fuels are basically fuels that must not be derived from biomass, but need to be based on renewable sources. The UK requires emission saving criteria of 40% to be eligible. A similar standard is applied by the EU, which requires, however, more ambitious saving, which is 70%. And here's where the EU stops. But the EU legal framework adds a piece to it, and it defines synthetic aviation fuels not only as those fuels which are RFNBOs, going back to the previous presentation, that allow a minimum saving of 70%, but that are also certified. What does it mean? It means that they must come, this fuel must be produced within a supply chain in which operators are certified by private third bodies, which are called certification schemes, that basically certify that they comply with sustainability requirements set out under the EU legal framework. And this is part, be mindful, this is part of the legal definition of these fuels. So a fuel that allows a 70% emission reduction, but it is not certified, it does not fall under the definition legally of the Refuel EU Aviation Regulation. And of course, so the point here that I want to stress is the different role that is assigned to recognize certification schemes under the EU and the UK. Under the EU, as I said, it's necessary to comply for the product to qualify for the targets. Under the UK, the role of voluntary scheme is much more limited because they are simply conceived as ways in which operators may, as an additional tool to prove that they indeed comply with the 40% emission requirement, but they are not necessarily, they are not obliged to get certified. Okay, so that is your rules. The point is all right. So the point here is really that, of course, as it was mentioned, the EU market. So the fact that the EU and the UK, which are said to be important markets for synthetic SAFs, are imposing these regulations, will have, of course, an effect to for third countries, so extraterritoriality.
But at the same time, they will rely, so to reach these targets, they will both rely a lot on international trade flows because of the current, I mean, at the moment in the EU, there is no commercial, there is no facility that can actually produce this type of synthetic fuels at a level sufficient to meet the targets. So, of course, we will need to develop some international partnerships somewhere, and this is already happening. I can maybe explore it a bit later. But we are already importing some, let's say, feedstock, some renewable fuel that we will then further refine in the EU. So just to look then, it becomes important, right, given these premises, to look at the interplay with WTO rules. So here there is a lot to say, but I will focus on the TBT agreement, also for the reasons that have already been highlighted by Kateryna very well. So just three really key points on this. Just really three key points on this. So the first, the basic point is the qualification of this measure, right? These key points, of course, draw from the most recent case law that we just discussed, so I won't go into detail on that. But as we have seen, both systems basically require the use of certain feedstock, which is renewable sources, but at the same time also prohibit the use of another feedstock, which is biomass, right? And this allows us to fairly conclude that indeed, based on these and on the conclusions of the panel in the case that was discussed, this measure could indeed qualify as a technical regulation under the TBT, regardless of the fact that this measure does not per se ban market access to third country operators that would like to sell in the EU market, but of course, as it was highlighted, there is no really demand for that. And this brings me to the second point. Basically, what the EU is doing also in this case is to regulate the demand, but also the consumption. So both, I will add one piece to what has already been discussed. Yes, thank you. So the demand and the consumption of these low-emitting fuels, and this would probably be considered legitimate because ultimately the idea, the aim is to decarbonize the emission sectors. There is really no other technical way to do that, right? But there is a but, and it is the last key point, which is the certification requirement that raises some concerns when we look at the necessity test under the TBT specifically. Because these measures, for the mere fact that they set, as I said, some targets, they would probably be considered trade restrictive. But what the EU is doing is adding an element that of certification and definition that doesn't really directly add anything in ability requirement per se, right? Because it doesn't ensure the further reduction of emissions. You're just asking people to be, economic operators to be certified, but it is complementary measures really. It doesn't add anything. And also, if we compare this the EU approach with the UK approach, it is more environmental operators, right? Because the UK simply asks for you need to prove to the official authority that you comply with this 40% requirement reduction. But you may be certified if you wish to, because you want to, be verified by a third party, but you're not really obliged to do so. So that's the aim. So to conclude, we believe that this current sub-regulation are falling with would probably fall within the TBT regulation. There are some most problematic features here. I will just highlight two. The first is that it's specifically for the EU, if we put too restrictive emission trading standards, this would, of course, be problematic from the perspective of also trade restrictiveness and the mandatory certification requirement, which may lead to the fact of discrimination for foreign ESAs suppliers. the next step of this study will then we expand this research further to include neighboring countries to the EU. So thank you very much. I'm sorry for the slides.
Thank you so much, Anna. Thank you so much. I think I will ask just a very short follow-up question, and then we can open it up to the general Q&A. Because you really respects the centrality, the definitional elements to this regulatory approach, right? So which of course also leads to discuss the centrality of certification, and in particular the lack of an harmonized certification or definition of this stuff. And this of course does not only apply when it comes to different domestic approaches, but that would also look at interplay with international approach. And here, for instance, you think of the aviation sector, you definitely think of, for instance, like House Garcia schemes, which yet relies on other certification requirements. Perhaps you could say a few words on this interplay.
This kind of, there is an overlap of two certification schemes. So you see, you have, I think, 40 schemes, but only two grant you in theory, because then all scheme has its own procedures, and you need still under the same scheme, let's say the ISCC, for instance, is one of these two schemes. You need double certification under the same scheme if you want to sell in the EU and outside of the EU. I hope this answers your question, which of course leads to a number of de facto discrimination and between operators. Thank you.
Thank you so much. I think we had the wonderful discussion already, but I am eager to open up the floor. I see already a few hands. I would have myself a number of questions, but I definitely give the priority to the audience. Please.
Does it work? Well, thank you so much to all the panelists for these so brilliant and so important and interesting presentations. I have a question that may be addressed to all the panelists, and it is the following one. As we all know, the panel in the EU palm oil cases condemned, let's say so, the European Union because of the way in which it administered its legislation on biofuels. And in particular, the problem was the delegated regulation adopted by the European Commission. The panels said that the problem was due to the fact that it was administered with old data. And so it was not updated as the same EU legislation requested. And also some of the criteria that were introduced in this delegated regulation were discriminatory and not justified. because the palm oil system, of course, is based on a crop that is there for many years, while on the contrary, the other kind of crops that were considered in the EU legislation do not last so long as the palm oil system, let's say so. And also, both Indonesia and Malaysia are trying to be very serious, and so they adopted a voluntary certification scheme certifying the sustainability of the oil, the palm oil that they sell on the market. So I think this is an issue because the panel said you are completely legitimate in deciding to drive the demand of your consumers, no, for climate change purposes, but you have to do it seriously. So you have to show up the data and to explain to us why just only the palm oil is excluded and does not get the certification for low ILUC risk biofuels, okay? While all the others have it, crop-based biofuels. So this is an issue. This regulation, delegated regulation, has to be implemented by 2026 January. This is the obligation, the commitment are taken by the European Union. So what is your view? Because we don't have an international standard, because these scientific data are basically statistics data, no? According to the observation that you have on how much land is not anymore left to forest, wetlands, and so this is one. And the second small question is specifically, I think, for Tetyana. Thank you so much. I mean, for making simple such an intricate question. In RED 3, the directives RED 3 of 2023, RFNBOs are allowed to be used for endothermic engines, while biofuels are not. It's problematic also from the point of view of EU law, but from the point of view of WTO law, do you see problems in these discriminatory or different uses of RFNBOs and renewable biofuels, let's say so?
Thank you so much, Elisa. Perhaps let's collect a few questions so that we can then do a round among the panelists. I see Caroline, Gabrielle, and the gentleman in the back then.
Hello. Yeah, thank you for the wonderful presentations. I'm interested to open up a little bit more this general discussion around standards, both in aviation fuel and more generally. Yesterday, we had a very good session in the afternoon around good regulatory practices. And one of the aspects of the discussion was that these are very procedural, they're not substantive. But what I'm thinking about is whether maybe reliance by governments in the EU on certification schemes could nevertheless perhaps become part of good regulatory practice, even though it has a link to substance. So that's my question. I also just had two quick clarifications. Did you mention a process for certifying the certifiers? So are the certification schemes required to be certified? And is there a link here to perhaps some of the GATT jurisprudence on prevention of fraud under Article 20, Korea beef, etc.? Ilaria Espa, did you mention a bilateral case that was relevant, and can you remind us of that case, if so?
Great. Then see Gabrielle. Yes, please.
Hello? One of the conclusion of the slides of, well, I think you all have that. You are looking at whether some of those requirements are discriminatory de facto or more restrictive than necessary. And one of the conclusion was that maybe one of the aviation requirement would be excessive for in terms of demand CO2 reduction. how can we conclude that it can be excessive for reducing CO2 since the goal of all that is to reduce? How can it be excessive? And my other small question, UK, EU have different standard now, I see, in aviation. How is it going to work between the two?
Perfect. I see also the gentleman in the back.
Thank you. Thank you. Just quickly, my question goes to Tetyana. Thank you for your wonderful presentation. And my question is about discrimination, like a follow-up question from the first lady over there. I am wondering, based on your presentation, if the red 3 creates kind of discrimination between the green hydrogen and the blue hydrogen. The blue hydrogen is of course, is produced from fossil fuels, but captures CO2 emissions. So it is not eligible as a renewable energy under the regime of the red 3. So there's no incentives for the EU companies to import the blue hydrogen because it's not eligible for as a target. So isn't it creating at the same time both of them, both hydrogen help reduce CO2, but at the same time it can be considered as a like products in terms of the impact of on the climate change. So my question is, isn't it creating discrimination between two products, or is the EU taking any other measures to avoid such discrimination? Thank you.
Thanks so much for all the questions. I don't see any further hands raised, so I will give the floor to the panelists. Shall we go in reverse order, or
maybe I can answer the first question because it was more about the findings of the panel and the implementation of the findings. I agree with Elisa that it's a very big question whether the EU will be able to bring this regulation, I mean, this criteria, etc., in compliance with what the panel recommended, and adjust it so that there is no arbitrariness in the application of this criteria. Also, the question is whether it would modify so that to include also soya-based biofuels falling under this high ILUC risk category. But then, of course, there will be more complaints in the WTO from Brazil and other trading partners importing soya-based biofuels. So I agree that I don't have an answer to that question, to be honest, how the EU is going to modify it, because this is so complex. It needs a lot of technicalities. I mean, the data, as you mentioned, on palm oil is not there, or maybe it is there, but it wasn't used properly. I mean, and yeah, it was one of the complaints. So yes, this is an open question. Then there was a question, I think.
I mean, you can also address any other.
Oh, well, whichever. Well, thank you so much for all the questions. First, maybe I'll address the question on good regulatory practices very briefly, and on the role of certification. And I think there is a difference to be drawn between the palm oil cases and then the new regulatory frameworks for SAFs and for RFNBOs. Because in the palm oil cases, the problem was that, first of all, the criteria for certification, or at least some of them, were not practicable, not feasible. So, as mentioned by Elisa, certain of the requirements were so rigid that they took into account only the EU circumstances, or better to say, the biofuel, so the feedstock that was growing up only in the EU, and which was the annual crops as compared to the perennial crops, which is the palm oil crop. But on the second problem was that the certification bodies had to be accredited. And at the time when the dispute started, there were no single certification scheme that was actually available because they were not yet accredited. So the delegated regulations that were dealing with that particular accreditation were not issued yet. So while the requirements entered into force, there was no certification body that was able to certify the biofuels as low and low risk biofuels. And then, of course, more broadly, there was a question as to whether it makes sense to have a certification of low and low risk biofuels that would still fall within the 7% limitation, which aims to address the same issue that is allegedly already addressed through the certification of low and low risk. So there is a set of separate issues there. The question from Elisa on the use, on the limitation of the use of green or RFNBOs, specifically for particular engines. I'm not familiar, to be quite honest, with that particular requirement. So maybe
under RED 3,
yes,
for the endothermic engines, so the one that are banned since, starting from 2035,
yeah,
you can use synthetic fuels, e-fuels, but you cannot use biofuels. And in my view, it's problematic from the point of view of the EU law, because the way in which you calculate greenhouse gas emission is different in the RED, in this circumstance of RED 3, by comparison to the way in which you can use biofuels under the EU legislation. And so, in my view, there is no basis within the EU, but there could be another case in the WTO by biofuels producing outside the European Union, say, but you are allowing e-fuels, why? And not biofuels.
Yeah,
So
well, I don't know. I'm not
something-
able to comment at this point because I'm not familiar with the rationale,
But-
because typically the EU has some type of explanation.
I was struck by
Yeah.
your stressing the fact that the EU industry, when reading the regulation of the RFNBOs, said we cannot cope with it.
Yeah.
And so I wonder, as a European citizen, I say this, I dare to say this, what about the respect of the rule of law, of democratic participation, which is one of the pillars of the EU decision-making process? And now we are seeing all this very significant debate on many measures of the EU Green Deal that are reshaped after few months.
Yeah.
Just as a general remark. So.
Yeah. Then maybe the question of the standardization and the standards, well, the standards that are set out in the delegated regulation and the double certification requirements. So here, again, an important distinction between the palm oil case and the present case. So in the palm oil case, as Kateryna mentioned, there were ISO standards available. In the case, at least, of the RFNBOs, there are just international ISO standards for greenhouse gas emissions or footprints and respectively greenhouse gas emission savings, but not really a broader set of standards, which means in essence that the EU as well as other countries can essentially set their own standards, although of course the cooperation is always welcome. But in this regard, again, going back to the element of good regulatory practices, what is possible, and I think what is also encouraged within the WTO framework, is to look for equivalence and mutual recognition. And this can be done both in part of the certification scheme. So for instance, the EU could say, well, if you have already the greenhouse gas emissions certified under the ICAO, we recognize it. But then for the other elements that are specific to our own requirements, you need to get an additional certification.
promotion regulatory practices. I know that the WTO is also now taking active part in promoting this good regulatory practices in setting emissions standards and methodologies, and they in particular joined the guidelines for the adoption of, for developing of standards in the steel sector called the 6 principles. This was a guideline, soft law, guidelines adopted by partnership of different international organizations and also industries, steel industry, etc. So the main aim is to promote this inclusiveness and interoperability of standards, and also the mutual recognition of certification of mutual recognition of conformity assessment procedures, and also different certification schemes, existing certification schemes.
Sorry, I take the momentum here. Yesterday it was also said, if I'm not wrong, that good regulatory practices do not necessarily bring harmonization to the extent that we expect them to, right? And here I think it's really important to stress, because maybe one point that is missing to those who are not familiar with this is that these certification schemes are really private enterprises. And so the logic behind it is really market-based. So operators would go to the scheme that costs less and that imposes less evidentiary burden, right? So the point here is that I think the better way to go with this and to ensure harmonization would be to delegate these to, for instance, in the EU, to create a dedicated authority for doing this. But we can discuss it. But I mean, just to go, because I think it is essential to ensure sustainability to go out of the market logic here, because it is proven that at the end of the day, it's just most of the times the due diligence is just a document, like a document analysis. There is nobody going to the premises of the operator. Sorry, I just wanted to stress this.
Okay, I think we did. Okay, so there's still a few answers missing. So who would like to address those questions? Okay.
Oh, no.
Maybe I quickly, so just quickly 2 points on Yoshi's and Gabrielle's questions. Yoshi, there is a separate regulatory framework for low carbon RFNBOs, low carbon hydrogen in the EU. So they differentiate between RFNBOs, so the green hydrogen and low carbon hydrogen. There is a separate framework. Whether there could be potentially discrimination in treatment, that's, again, I mean, how much leeway you give to a country to differentiate between different types of fuels. On Gabrielle's question, so my point was that actually the RFNBO requirements may, in practice, impede imports of any type of RFNBO that is produced abroad, unless the electricity electricity market is essentially the same as the EU market, which would exclude the majority of our RFNBOs produced abroad. So that was my point in the, potentially national treatment discrimination, but not the other parts. Yeah. Yes, de facto. Yes, de facto, yes.
And indeed, I mean, we see in Switzerland, for instance, as an obvious suspect, explicit alignment to the regulatory framework, the EU, in the revised version of the CO2 Act, precisely for these purposes. Any further questions?
So just
Later, so we will conclude later with apologies, ROs.
Very briefly on who certifies the certifier, right? So both under CORSIA and the EU, I did look into this. As Tetyana mentioned, these schemes need to be accredited, and this accreditation under CORSIA is based on a decision by the competent internal organ, which I think is the technical competent authority or something like that, the TCA, which conducts an assessment of the standards applied by the scheme and so on, and at the end of the day decides whether to give the accreditation, so determines whether the certification program aligns with the CORSIA program. And then the schemes, what they usually do is that they provide like a basic CORSIA certification program, but also they also provide a sort of a CORSIA Plus certification program, which still complies with the CORSIA, but requires some requirements more from the operators. And almost the same is done under the EU by the Commission. So there is a sort of control. We can debate whether this is effective or not, considering some scandals that have been raised in the last year regarding UCO, for example, and yeah. And as I was mentioning, most of the time it's just a document review. And just to go back to Professor Marceau's question, excessive in terms of, I mean, the problematic point here is, I think, so first of all, the slide tried to condense a very long discussion. Yes, absolutely. But it really relates my point to what Tetyana was saying. It's really a de facto, yes. And also for the emissions, the lack of common standard there. When you have the UK imposing a much lower standard, because the 40% is kind of a big relevance, and also the CORSIA at the international level requiring a 10% emission reduction, that could be debatable whether it is a bit excessive, also from the perspective of trade.
Great, thank you so much for all of your inputs and a wonderful discussion. And thanks a lot for staying with us even a bit beyond time. I think we can now close this panel, and I would like to give a round of applause to our panelists.
Thank you everyone for coming. Before you leave, we would like to take a group picture of the panelists and the audience. Panelists, if you could move to the third row of the classroom. Thank you very much.
Take a group photo?
Thank you very much. 3, 2, 1, take field. Yeah. 1, 2, 3. Thank you very much.
Thank you.
Thank you so much for
Sorry.
No worries.
Thank you so much for your help.
Thank you very much.